and welcome everybody as you filter in for our webinar as part of our Method for Success series. How did you win that case? This webinar is going to be about a phenomenal $73 million verdict against Ford Motor Company in Sacramento. Let me underline that, Sacramento. Two lawyers who tried that case are with us. One is Chris Spagnoli from our law firm. Chris has been the trial lawyer of the year for the Consumer Attorneys Association of Los Angeles. She's been president of CAOC and received innumerable awards from all these organizations that I'm not even going to list. Roger Dreyer from Sacramento is one of the greatest trial lawyers in the country with a whole string of phenomenal verdicts, outstanding results in a difficult jurisdiction. And we are thrilled that he is with us and being part of this webinar that we're putting on for y'all today. You're going to learn a lot. I'm anxious to see this, and let me tell you why. Not only was it a great verdict, but it was against, as I said, Ford Motor Company. I myself have tried, I think, 7 auto design cases in my career, and I can endorse what the great Dick Goodman, auto design lawyer from Detroit, once said. He said at the beginning of a seminar, until you have been in the pit, in trial, against the auto industry and have seen the whites of their eyes, you have not been in trial. They are really tough, and in this case, the best of their defense lawyers that I've also been up against, Warren Platt, was the defense lawyer. This was a tremendous verdict, and you're going to learn today how they went about obtaining this magnificent verdict. Also want to say, you can ask questions as we go along. They're going to put on their presentation using a PowerPoint. You ask questions along the way, and when they're done with their presentation, I'll come back on and pose some of the questions. I'm sure I won't be able to get to all of them that you all have given to us. I also want to say one more thing. You can download the syllabus by pressing your handouts thing and download it, and you will receive the PowerPoint syllabus that they have worked hard to put together. So with that, I'm going to turn it over to a great trial lawyer, a great friend for a long time, Roger Dreyer.
Thanks, Bruce. Welcome, everybody. This is a very challenging way to present information by way of a webinar. We're all kind of dealing with this new normal of interaction. So welcome, and Chris and I will try to do the best to impart some information to you relative to things that we have learned through the course of this case and things that we believe made a difference in how we ultimately were successful. This involved a case that happened back in 11 years ago. We tried this case, 9 years ago, in 2011, but it involved an incident that happened back in April of 2004, and it was a rollover case involving an E350 van that killed 2 people and injured others that were in it. It's a church van. What these vans would be used by schools and churches. You see the photograph on the PowerPoint. That's the residual of the van itself. Case dealt with a tire failure that resulted in the driver losing control of the vehicle. It has everything that a products case you're going to face when you have a products case. It has issues of comparative fault. It has dealing with a manufacturer that wanted to protect its reputation and its vehicle. It has amazing engineering components too that you as a lawyer need to learn and understand so that you can articulate it and educate jurors on it. It had drama to it. It had secrecy. It had going through and finding information to implicate Ford. It had, in terms not of just of their responsibility, but of the event, but for bad conduct relative to knowledge and putting people at risk to allow us to pursue punitive damages, which were awarded in this case. It has the amazing human experience. Tony Mauro was killed in this event. I represented Tony and his family, and getting into the depths of that individual and his relationship with his wife and his two boys, and going through that growth. So as a human being, it had all those components to it as well. So when we had this case initially, I litigated this case with one of my young partners, Bob Bale, who did a phenomenal job working the case up with me. And we reached a point in the course of our discovery in this case that we needed to get access to information, and we just frankly did not want to reinvent the wheel. And I have known Chris Fagnoli, and I know a lot of the principals in her firm through the years, and that's one of the beauties of our organization, CAOC, where you get to meet other folks that are very talented and have done things. And so Bob and I reached out to Chris because we knew that Chris had cases through her office dealing with E350 vans, and she had done some remarkable things in those cases that really ended up playing a huge role in our prosecution of this case. Not only in that she had done discovery and taken depositions that we used in this case, but she had reported to NHTSA things that she had discovered in the course of litigation, which miraculously NHTSA acted on. And in fact, our firm has modeled some of the things that Chris did with governmental entities about reporting what we discovered in litigation to the appropriate governmental entities so that we start creating that record for the next case. Well, Chris did things on cases she had in her firm at Green Burlette that had laid the foundation for things that we were ultimately able to do in this case. This case ended up being, I think, a seminal case relative to Ford, and Ford ultimately stopped manufacturing the vehicle. I mean, they're still out there, and these cases inevitably will continue to go. But we reached out to Chris, got her involved, and ended up ultimately this case going to trial back in 2011. And, you know, just as a practical thing to think about for you, when you get a case where you have multiple plaintiffs, you can't be greedy, and you can't be thinking only of yourself. You have to think of as well, I think, of the clients. And in this case, we had multiple plaintiffs. We had two individuals that we represented, two families. The driver had been killed as well. And initially, we had Chris represent that family. That case, we made a tactical decision to settle it, but we had other plaintiffs. And so we were able to keep her engaged in the case by having Chris represent one of the passengers in the vehicle. So I think, Chris, I'll pass it on to you. Maybe you can give a little bit of a background about the history of the vehicle. But the point I'm making is, keep in mind that if you have a case with multiple plaintiffs, it's really valuable sometimes to reach out to other lawyers who have experience in that you don't have. Doesn't mean you're not an excellent lawyer, but just that you can harvest another resource that ultimately puts you in a position to do what you want, which is to prevail for your clients. So Bob and I were obviously thrilled that we brought Chris in, and it was a very collaborative effort, which ultimately we'll talk about in terms of the trial itself, about working with other lawyers and how you do that in such a way that it ends up being to the benefit of the client. So Chris, why don't you give the folks a little bit of history about the van and Ford.
Great, thanks, Roger. And I was saying before that really coming in and working with you and your firm and Bob, who's terrific, on this case was really one of the highlights of my career as a trial lawyer. It is a case that had just a little bit of everything and a lot of dynamics in the courtroom. So tremendous experience sharing it with you, and I really appreciate your getting me involved. So a little bit about the van and the history that got us to this trial. The van itself was a 1993 E350 15-passenger van. It was owned by the First Presbyterian Church of Fair Oaks in Sacramento. And like many of these 15-passenger vans, it doesn't get used a lot. It sits on church parking lots. It gets used to haul students for ball teams. It gets used for transporting a lot of people at one time. And the church had owned this van since 1993, and they were using it on this accident trip to cart the band. The band was of the church was traveling along with the students who were on a spring sing, if I'm recalling correctly. They were all in a charter bus, and all the band members were in the 15-passenger van with their equipment. I think there were 5 people in the van. The van, when it was originally sold in 1993, had a Goodyear Load Range E tire on it that was an original equipment tire that didn't have a nylon overlay. None of the tires did. And that was the key issue in terms of the tire failures in this case. So in 1999, the tire that was ultimately the tire that failed was installed by Sears on the van. So the church takes the van to Sears, gets a tire put on in 1999. And a year later, NHTSA opened an investigation into Goodyear tires. And as Roger mentioned, that investigation was opened about 3 months after the Firestone tire recall occurred in August of 2000. And in October of 2000, I had a 15-passenger van case involving a Goodyear Load Range E tire involving military officers. And I had gathered a collection of other incidents involving these vans and had sent it to NHTSA and said there is a problem with these tires because of an earlier case I had representing a police officer who was injured when a Goodyear Load Range E tire failed. And I had gotten discovery and had to return it at the close of that case. So anyway, NHTSA opens an investigation into the tires. And in 2001, Ford internally decided to change the tire design on future, going forward, 15-passenger vans and started using the same size tire with a nylon overlay. So we had all these, this van has been in production for years. From up till 2001, all the vans that were sold had the old style tire with no nylon. And in 2001, the tires that were put on the new vans sold after that had nylon. NHTSA in 2001, correspondingly on a separate investigation, decided to issue for the very first time and the only time an advisory to consumers that 15-passenger vans have a high rate of risk of rollover, particularly when they're loaded. And that's with good tires. So there was an advisory issued in April of 2001 by NHTSA about how these vans are dangerous. And then ultimately in January 2002, Goodyear recalled the Load Range E tires that did not have nylon. Now that's really important. And the key issue in this case was that Goodyear did the recall. But in order to do the recall, they had to go to Ford and the other manufacturers using these tires and ask them for a list of vehicles that had the recalled tires on them. So they could, then Goodyear could reach out to those consumers and tell them to get different tires on their vehicle. Ford did provide a list to Goodyear of the vans that had the tires as original equipment. But our van, this 1993 Ford van, was not on the list because it had a weird issue with the VIN number that was sold as an incomplete vehicle, not as a complete vehicle. It's not important. They didn't get the notice from Goodyear. Meanwhile, Ford basically said, it's not our recall. It's not our job. In contrast to what they had done with the Firestone recall, where on Ford Explorers, where Ford actually took the initiative to get those tires off Explorers. So in the Goodyear recall, they said, not our problem. It's Goodyear's recall, and we don't have to do anything. So this church did not have any notice from anyone that their tire on this van was a recalled tire. And from there, Roger, the next slide just shows what happens So we remember the date, 2002, February 2002, the tire is recalled. In 2004, this van rolls over because the tire tread separates, the van goes out of control as anticipated, and that's the reason they were recalled on 15 passenger vans, because of the threat of loss of control and rollover. And 2 people died and other people were injured. And this is just the aftermath of that scene. And so what happened between 2002, the recall, and 2004, Roger's going to talk a bit about the issues in a bit as to why our theory was that was Ford's responsibility to do something. So before we get to that, I think we're going to talk about the voir dire issues next. So let's go to the next slide. And you want to just talk a little bit generally about voir dire issues, and then we've sort of got a list of topics on this that we were going to talk about.
Sure. So in these kind of cases, to make it useful for everybody listening in, when you have a products case, inevitably you're going to have other parties. And so one of the things you have to think about, there's not a template you follow for each and every one of these cases in terms of how you're going to tactically prosecute your case, but you have to think about what are the cards you have available to you. So in this case, we had a lot of different people, a lot of different entities that potentially were defendants. And when we initially filed the lawsuit, when Bob and I initially got involved in this case and represented the families of the folks that were killed and the individuals that were injured, we had to look at all the different defendants. So as we approach the voir dire issues, you're also making tactical choices. So in this case, we had Sears, who did repair work. We had the distributor, the Ford dealership that also did maintenance and work on the vehicle. We had Walmart that was involved with the tires, and we had the church, and we have Ford. So we have a lot of, and we have Goodyear, who manufactures the tire. So when we initially filed the lawsuit and we spent the time figuring out who we're going to sue and why, we ultimately go through and utilize those parties to gather information that we then are ultimately going to prosecute. But before we ever get to the voir dire, we had lost defendants. We had settled with defendants, and there's always this issue of having the empty chair, which everybody deals with. And so you have to make those decisions, which we did early on in the case, to get rid of the church, to get rid of Goodyear, to settle with those defendants for a myriad of reasons, which would take a webinar to just go through that tactically. But these are things you have to think about as it relates ultimately to when you do jury selection. And then you're also dealing with the posturing of your case versus the key defendant, which is obviously Ford. We know now that we're going to have a bunch of people, and you'll see the verdict form. You're going to have all these other parties listed, and the jury's going to have to assess that. So when you're picking a jury, you have to understand, A, what you've done and what the implications are and how you're going to try your case.
Just some bullet points, Roger, that we can talk about that when we were doing voir dire, we were working on. And, I'll start out on the Ford issue. One of the keys in a products case is you really, and particularly in a case involving Ford, you really have to explore people's loyalty to a brand. And Ford, there are, I would say, 2/3 of the folks on that jury panel owned a Ford, were prior Ford owners, loved Ford. Lots of folks who just had a trust in Ford, and we really had to dig in and explore those issues and look for people who not just loved their Fords, but were going to make it harder on us to prove our case because of their experience with Ford Motor Company. On the other hand, there were also some anti-Ford sentiments because there is a history of Henry Ford, some of his anti-Semitic beliefs, and there are some people out there who just would never own a Ford, and so Ford was interested in looking for those people. And Roger, passing it back to you, I'll just say one of the significant issues in the case was the seatbelt defense issue that Ford had. And you and I had a lot of conversations about how to approach that. And it's really a case-by-case decision. But my experience in the past had been, if you have a client who's not wearing a seatbelt, it makes sense in many cases to concede some fault. Roger went the opposite direction. Roger felt very strongly that he could prevail on the lack of a seatbelt for Tony Mauro, which we acknowledged he wasn't wearing a seatbelt, in terms of addressing, whether or not there would be a percentage of fault on Tony Mauro for not having a belt. And so how did you deal with that in Voir dire, Roger?
Well, let me take a step back and I'll address that. But again, keeping it in the context of what people can use. In a case of this complexity with this many parties and this many issues, whether it's loyalty to the product, the brand, comparative, wrongful death, punitive damages, all the different topics we had to deal with. That's just a quick little list. How do you do it? In this case, we used a jury questionnaire, and this also speaks to the collaboration of the lawyers. We had another lawyer, Bill Callahan, who represented one of the passengers, and we had to make a decision about how we were going to do jury selection. Ford had its group of people, their lawyers, Warren Platt that Bruce mentioned earlier. I mean, I've tried a lot of cases over the course of my career. Best trial lawyer I've ever dealt with in terms of skill set and advocacy. So it all starts really in that jury selection of how you start positioning yourself to win. And we came to a conclusion that I would do the jury selection so that we were speaking, because I'm representing Tony Mauro, who is the decedent. And these cases really, what Chris had done early on relative to bringing this message out and educating people is these vans had the ability to kill not one person or two people, but 15 people. And we needed to really get the jury to focus on that issue, not so much injury, which we did have some people that were injured, but the ultimate injury of death. And so we did the questionnaire. They had their jury consultants. We did not use a jury consultant. And I'm not saying that's the right way or the wrong way, but I have a pretty good sense of Sacramento and people in Sacramento, and we felt comfortable we didn't need to do that. And between the combined experience of the lawyers on the plaintiff side, we'd be able to have ample information to make good choices. But the questionnaire in a products case is absolutely something you have to have to ferret out things like brand. If we ask every single person about their experience with Ford and do it verbally, you're not going to get honest answers, and you're not going to get the information, as opposed to filling out a questionnaire. We had a great trial judge, one of the very best, Dave Abbott, who allowed us to do our jury selection, both sides. I mean, he was very neutral in his, but he allowed us to use the questionnaire, and it was a very extensive questionnaire. And, assuming someday we get back to doing jury selection in civil cases, we would use all these different elements throughout the course of the jury selection. Some questions you don't ask. You don't give people a podium to get behind and give their views. Some you do. But we used the punitive damage claim. When you have a viable punitive damage claim, it does allow you to look and evaluate people relative to, if they just absolutely would never award punitive damages, they're so viscerally against it, you really have a great insight into their view on other things. Wrongful death, same thing. There are people that just cannot understand how they can determine the loss of another human being to the family. And that's another thing that allows you to get educated on who you want on your jury as to a product. So all of these things during the jury selection and asking questions, which again is something we can do an entire seminar on, you just have to be aware of these issues that, as it indicates here, the fault of others, other defendants and non-parties. You have to bring that out, and we did that in this case to find out how jurors would feel. Like, for example, Goodyear wasn't going to be there, and they had the defective tire, which was essentially admitted. We had to explain the tire architecture so the jury understood what happened and how much information Ford had from the other recalls and this recall. But jurors sitting there going, well, why isn't Goodyear here? Having to explain it without explaining it in Voir to allow that to see, can you sit on a case where you're going to hear about it, but you're going to need to be looking at, we have one defendant here. We don't have Walmart. We don't have Sears. How are you going to react to that? So the jury selection process in all these civil cases, anybody who tries cases is going to tell you you win and lose there. We were very fortunate to have great latitude to do jury selection. I think, Chris, jury selection took us 3 days. I mean, it was a very extensive, and that's really up to the judge. Obviously, we were not in federal court, and Abbott allowed us to do both sides, do an extensive voir dire and get familiar with the nature of the case, so that we then had, I think, a tremendous launch pad to get into the case, because we used defendants that were no longer in the case as a way to educate the jury on what they're going to be hearing about. But
well, and I think one of the really important functions of the voir dire was to, first of all, ferret out people who think there can only be one cause of an accident or a death, and that, you know, to the exclusion of others. If they didn't have their seatbelt, it's all their fault. If the driver lost control, it's always the driver's fault. And so I think during voir dire, there was education going on about this really was a percentages of fault case, because we knew there was going to be a percentage on Goodyear regardless. There had to be. You can't avoid it. The function, what we were trying to do was minimize the fault on the tire and address why it is that the vehicle was the primary cause of the loss of control. And so that was something we addressed in voir dire. I know you talked about percentages. There were many questions on the jury questionnaire that kind of ferreted out those issues. And that questionnaire, it was a collaborative with the Ford lawyers. I mean, we had to agree on the questions. And
yeah, I would recommend that if you do get a questionnaire, one of the things, you know, skilled defense lawyers want to have a questionnaire as well. In this case, I reached out to Warren. I gave him a questionnaire, said, let's work on this together. So by the time we got to trial, we had an agreed to questionnaire. So I'd strongly recommend that's something that you think about doing. Don't wait till you get to the courtroom, because they're going to still run into some judges that don't want to use questionnaires. If both sides come in and say, we want a questionnaire, then you're going to get it.
And we have that questionnaire, Roger. So if folks want a copy of it, you're going to have our emails at the end, and we'd be happy to send you a copy of it. It's got a lot of good stuff in it and helpful, and that are still, in any products case, I think, relevant. So anything else you want to talk about on voir dire? Should we go?
We could go for days. So let's go to the next slide.
Okay. So now let's talk about the Ford liability issues. And we've kind of broken this up into two sections. As you remember, we had the tire on the van as of the time of the recall in 2002, and then the accident in 2004. So there was a significant amount of time where the focus on Ford was, why didn't you tell the church or your own dealers that this tire needed to be removed, that these tires had to come off? And the second issue on liability of Ford was the van itself with 4 good tires is unstable and prone to roll over. So with 4 good tires. So when you add a bad tire that's prone to separation, it makes the situation catastrophically worse. So Roger, why don't you talk first about the service issues, the notice issue, how we approached the Ford responsibility for not telling its own dealers that the tires were subject to recall.
Sure. Maybe we can go to the next slide just to illustrate what we're going to do. So Bob Bale really did a phenomenal job on working through the maintenance records, which are not exactly the most exciting thing to do. But this, I'm going to just show you, these are some slides from closing argument that Bob developed with our phenomenal IT guy who no longer is with us, Brian Claykel, who did an enormously challenging, positive job. But you can see we had a history of this vehicle getting maintenance. It was in 1993. It had all sorts of maintenance, and what the theory was to get it in front of the jury, how many times it was in at the shop for people to look at it and check it out. And then the key time frame obviously was after the recall in 2002 and what happened in that time frame. And this took us days at trial to develop, to put the evidence in front of the jury, to go through maintenance sheets, to make it interesting enough so that they would pay attention to what was going on in maintenance, but set up by the opening statement to explain to them why this is so important. But we did this, and I think do we have another slide on this? Yeah. That just, this just shows the animation of it, where we were able to work backwards to show the volume of times that the tires, people had their hands on the tires to such that, and then the key time from the 2002 to 2004, where Ford has the information, has the knowledge, has the documentation, understands what NHTSA said, understands what Goodyear said, and they're not communicating this information to their own dealer. And truly one of the most powerful parts of this case, Bob had done great work on depositions and cultivating witnesses. And we put on, I remember doing this examination of the manager of the service department and going through these records with him, laying the foundation for it. And then also we had previously put in the information about what Ford known. So information that Chris had cultivated in her cases previously against Ford, and then putting the question to him. And this is an example of using one defendant against another defendant. And it's extraordinarily powerful in products cases. And if you dig hard enough, you will find information like what we had in this case, where you have one party, whether they're still in the case or they've settled out, that says, points the finger at the main defendant you have. And my questioning of this individual was, would you have liked to known this information? Would you like to have known about the recall? Would you like to, if Ford had known this information, knowing what documents we had, would you like to have had your manufacturer provide this information to you? Did you have an expectation? Then you're dealing with the safety of your customers. Did you have an expectation that Ford would tell you these things? And this guy literally broke down on the stand and was weeping. And and just a really good, solid, what you would expect in a service department. And I mean, his testimony was extraordinary about communicating. I would love to have known. I wish they had told me. So that's where you start. You don't get punitive damages on one document. You get it by building a level of understanding of what Ford knew. And obviously that information, when you start getting a jury angry, this is no secret to anybody. They are looking for people to hold accountable. And ultimately, the punitives are nice, but we want to get our clients compensated for their injuries and their non-economic and economic damages. I mean, Tony Mauro made $40,000 a year. It was not a big wage earning case. It was a non-economic damage case. That's really what this case was about. So that was one of the things. Again, we're thinking of the different layers we're building. So I don't know, Chris, maybe you want to add something to that relative to how powerful that testimony was.
Yeah, and I think that testimony of this was the manager of a Ford dealership who took the stand and said, yes, my people touched that van. And by the way, there's a computer system in their Ford dealer service system that connects to Ford Motor Company in Detroit. And Ford puts notices on that system. So when you plug in the VIN number of a vehicle, you get told whether there's any recalls or any service or technical issues that need to be addressed. So all it took was putting the VIN number in and Ford putting something on that system telling its dealers, look out for these tires. And Ford did not do that. And one of the building blocks to why this conduct in the Goodyear case was so extraordinarily reprehensible is that Ford had put notices about tire recalls for other tires, like the ATX and Wilderness tires on Ford Explorers. They had put some on other tire manufacturers, and we ended up getting in evidence the notices that they had put on that system for other tire recalls, and had not done it on Goodyear. And you're going to see the testimony. I think ultimately that was the linchpin there on why I think the jury gave the punitive damages. So
this next slide talks about that evidence that was presented. And again, in terms of trial practice, it's all about timing, who you call when you call them. And we layered, this case took 6 weeks. So we had to layer the information in a comprehensible way for the jury to understand and build. You know, we had 17 jurors. We had 5 alternates. This case was so compelling, we didn't lose a single alternate, a single juror. All 17 people stayed the entire trial.
Right.
So this was, why don't you take the folks through this? Just
Sure.
Again, this is not to tell you how impressive this case is. This is just to explain to you, this is what you need to get on these products cases if you choose to get them.
Well, and I have to say, on the 15 passenger vans in particular, there is a legacy of lawyers around the country who have done amazing work in uncovering things going back to the 70s from Ford. So we benefited from the fantastic work that other lawyers had done. We played depositions that were taken by lawyers in other cases in our case. And this is, for the lawyers who do automotive product liability, that is a key to how we succeed. And what the manufacturers try and do is prevent us from collaborating. So one of the big fights in these cases, and we had it in this case, was whether or not to have a sharing protective order over the things we got produced in our case. And because other lawyers had fought that fight before us, we were able to get information from them, and we knew what was out there. We had to get it into a position where we could get it in evidence. And so just really quickly on this timeline, we had evidence that Ford knew that its old tire design was defective. They knew their vans rolled over. One of the key witnesses we put on was a deposition taken by other lawyers, including Dennis Mulvihill from Cleveland, of a Ford test driver who rolled over a 15 passenger van on a test track in the early 90s, and Ford had not changed the design. They knew that the combination was deadly, and they knew about the recall. They knew that they hadn't given the VIN number to Goodyear, and that there was no way for the owners of this van or other vans to get the information. So what was the problem with the van itself? This van has what's called an oversteer response in emergency avoidance maneuvers. It's a function of literally the width, length of the vehicle, the length of the wheelbase, and the rear overhang. And if we go to the next slide, let me show you what we mean by oversteer and understeer. Understeer is good. It's when your vehicle plows out. And oversteer, next slide, is bad. Oversteer is when you put in a steering maneuver and the back end breaks away. And in these 15
Chris,
yeah.
Let me just interrupt you real quickly here. Just give a shout out. Chris introduced me to an expert that she had used. His name is Mickey Gilbert out of Colorado. I've used him in other cases since. Mick is a remarkable driver handling expert. He can do reconstruction as well. He's got an engineering background. But on this case, because of his race car driving history, his pedigree and experience, I'm internally grateful to you, Chris. And this again is another example of collaboration of introducing me to Mickey. And so if you have a case where you need someone who can talk about handling, and this also lends itself ultimately to the rollover sequence, which lends itself to the seatbelt issue, which lends itself to comparative fault against the driver, because they're going to blame the driver for failing to operate. So just want to make sure that I get that name out there. And I know, Chris, you would have done that as well, but great expert.
Yeah, and Mickey, I was going to follow up, and I'll tell you what really was the point that Mickey was able to deliver is the safer alternative design. So the initial is, why is this happening? Why is this vehicle fishtailing? And if we go to the next slide, and this is, again, 4 good tires. So it gets worse when you have a bad tire, but even with 4 good tires, what did Ford know? This is an example of the evidence we had in the case. This is a document from 1974 when Ford was first coming up with the idea that they wanted to have this larger vehicle carrying capacity because they were starting to get competition from other manufacturers. So if we go to the next slide, you'll see what their design choice was. They could extend the wheelbase and add dual rear wheels, which is the right side of the slide, or the Bustleback. The Bustleback is literally, let's take a 9-passenger van and add a row behind at the back that we can put another 5 people in and make it a 15-passenger van, or maybe it was I don't remember if it's 11. It went anyway. They added, you'll see in the next slide, what they did was they decided in 1974, increased capacity dual rear wheels and a longer wheelbase was what their engineers told them to do to make the vehicle stable. What did they do? Next slide. They went to the Bustleback instead, and they said, okay, we're going to wait a while. We'll do the dual rear wheels. We'll do the longer wheelbase down the road. They never did. They never changed this design. You will see this vehicle all over the road when you start, and they're always white. I don't know why, but start looking for white big vans, and this is what they look like. They have an extra 20 inches on the back behind the rear axle. And when you load this vehicle and you put weight in the rear, it makes it worse. It makes it harder for the drivers to control the vehicle. And what you're going to see next is what happens in a loaded van with 4 good tires. This is a test for litigation because Ford had no documentation of the testing they had done, and they were starting to get sued for these vans. So they had their litigation experts go out and test the vehicle to show juries why it was so great and why it really wasn't dangerous. Well, what they didn't know is that we, not me, but other lawyers, again, collaboration, got the raw footage of the testing. So they gave us the pretty cleaned up package. This is an outtake of what happens when a fully loaded 15-passenger van is going through a steer maneuver on their own test track. So go ahead and play the video. Pretty scary. And we had a lot of those kinds of examples from their outtakes. So Ford brought in their expert, Mr. Lee Carr, who showed the good tests, and then we had side-by-side comparisons of the tests, the vehicles going out of control, again with the 4 good tires. And what Mickey Gilbert did that has stood the test of time is he took one of these vans and he equipped it with dual rear wheels. So didn't move the wheelbase, but added dual rear wheels and did testing that demonstrated that this vehicle was far less likely to go out of control from a steer maneuver with dual rear wheels. And Ford, we have won these cases on the back of Mickey's testing that this vehicle is dangerous unless it has dual wheels, and that's what their engineers told them in 1974. So moving on, a couple of the other pieces of evidence that we got in about Ford's, this was for notice purposes. And we had a big fight over whether the jury would be told that the government, the National Highway Traffic Safety Administration, had warned consumers that these vans were dangerous. This is the first notice that NHTSA sent. They do it every year because about this time of year, these vans are out on the highways for people going on vacations, school trips. And the summer seems to be when we're seeing these accidents with these vans, including with these tires. So the consumer advisory basically said that 15-passenger vans have a higher rollover risk that is similar to other light trucks and vans when carrying a few passengers, but when you put more than 5 people in it, the center of gravity goes up and rearward, and it becomes more difficult to control. So this goes to Ford, what Ford knew about the hazards of these vans. And then the next slide is, this is a NHTSA, what's called a closing resume. This is a Ford document. It's got a fax track on the top. No, nobody uses faxes anymore. But in March of 2002, Ford got from the government a closing notice from NHTSA that Goodyear was recalling the tires on 15-passenger vans. And the next slide is a different closing resume for Steeltex tires. These are Firestone tires. And there was an ongoing investigation for all these large tires. And what NHTSA concluded, and what was important to show notice to Ford, was that the full, you can see I highlighted the section, full-size vans are disproportionately involved in the severe crashes. So they were looking at tire failures and the type of vehicle, and they concluded that in these large vans, if you had a tire failure, you were going to have a severe crash. And the van itself was a part of the reason that that would happen. Again, we got this in for notice because this is a document that came out of Ford's own files. Big fight over whether there was hearsay, whether it was admissible for establishing what Ford knew or didn't know. And then, as we talked about, Roger, in a punitive damages case, this evidence was critical, but even more so was Ford's own engineers and its representatives who were testifying for the company. When we asked them, why did you not tell consumers and your dealers about this recall? You're going to see a short clip from a Ford representative, Eric Callis. He says it's Callis. I say it's callous. And this is callous disregard, as clear as day. And this is just one question and answer from the deposition taken in 2011 that Jessica's going to play. After February of 2002, was it acceptable to Ford Motor Company that an owner of a 1993 E350 van continued to drive on tires that were manufactured in accordance with the tire construction detail sheet we've marked as Exhibit 52?
Those particular tires had met our requirements at the time, yes.
So after February of 2002, Ford did not have a concern that consumers who owned a 1993 van that had Goodyear LT 245 75 R16 load range E 4-ply tires continued to drive on those tires.
And the tire, when we had signed it off for the 1992 model year, had met our requirements up through the 99 model year.
So is your answer that after 2002, Ford did not have a concern if consumers continued to drive on that tire?
Not that I'm aware of.
Okay. Ford was aware, however, that the tires were recalled and replaced by Goodyear on those vehicles, correct?
Ford was aware that Goodyear was replacing the tires.
And even though Goodyear was replacing the tires, Ford had no concerns that those tires, whether they did or did not, remain on the vehicles?
Again, the tires that we had signed off had met our requirements.
So is the answer yes? Ford was not concerned?
Again, this was something between Goodyear and NHTSA, so the tire had met our requirements.
So Ford was not concerned?
Yeah, as far as I know.
Is that kind of tells the story, I think. And then lastly, we also had testimony from earlier cases. Again, this was from the Firestone Explorer recall. This is Jack Nasser, who was at the time the CEO of Ford Motor Company, and he gave some good testimony on whether or not a tread separation on a vehicle was dangerous and whether or not Ford should blame the driver. And in this little clip that we were able to play, again, notice to Ford, you shouldn't be blaming the driver. So this was helpful for us in the comparative fault discussion about whether to put any percentage of fault on the driver. Roger, did you want to add anything on this section before we go to closing?
Yeah, the key on this is, again, we're compressing 2-3 years of litigation and a 6-week trial into a very short period of time. But I would think we all understand the importance of video depositions, but when you're going to take someone like Mr. Callis or Nasser, you got to do these by video so that you can use them at trial. Even if they're going to maybe potentially testify at trial, you want to have that. It gives the jury a break from live testimony. You are able to edit it. You are able to do things with video. And I remember when his testimony was played, the courtroom was dead silent. You could have heard a pin drop because they wanted to hear and they wanted to see what Ford was saying. And obviously we set it up by, this is the person that they produced that's most qualified, most knowledgeable on this topic. And it helps obviously on the punitive damage case, like the notice documents do, but it also helps you drive your damage case. And because you want to have a very attentive audience when you start talking about loss, and you want them to understand who's accountable, and they have faces in a case like this. And it's not just, Ford, it's any manufacturer. I've had cases, and I know Chris has had cases where I've gone someplace for 2 weeks to take video depositions of corporate personnel. You got to spend the money, and if you can't spend the money to get the videotapes, then you need to collaborate with someone else who will spend the money, because you miss out on opportunities. Reading testimony it can be effective, but it's not like what you just saw with video. So please make sure you take video, because those moments, once they're lost, they're gone.
And there's always the challenge of being able to use testimony from other earlier cases in later litigation, and this is a fight that we have. And so you want to, study up on use of prior testimony and whether or not there's a similarity of interest in the current case. So we've thankfully, as Roger said, we had a good judge who got these evidentiary issues, and let us get in.
I said we had a great judge, because he was great.
He was a great judge. So let's go ahead and move on to closing argument. And really, we've kind of broken this up into a couple of key issues. And Roger, I'm going to pass the baton back to you to talk about the argument on the seatbelt defense in particular, which was your baby.
I appreciate that. We're running, I think we're almost close to 11 o'clock, so I'm going to speed through this as a general concept. He didn't have a seatbelt on because he was ejected, but the issue was, when did the seatbelt go off? And why don't you go to the next slide for me, please? There's the instruction. You have to, I learned this as a DA, a lifetime ago. You got to know what the law is, how you're going to then set up the game plan for your presentation of evidence. So we had a specific instruction dealing with the seatbelt and the different things they had to prove to get this comparative fault. So we're trying to break out some of these elements. And in our case, please go to the next slide. Our case, we had this massive rollover, 4.5 rolls, and the reconstruction was essentially the same between both sides in terms of this. So that plays on not only the drama of the event, go to the next slide, please, that plays also to this issue of the seatbelt and the experts. I had, and have used him many times, a gentleman by the name of Toby Hayes up in Washington, who's just a tremendous biomechanist and puts everyone else to shame. He was against anybody who's done products work knows Mr. Pizziali, and he's the defense guy that they always use, to say that, you know, hey, if he'd been wearing a seatbelt, this guy actually testified that if he was wearing a seatbelt and it was stayed on, he would have been fine. Basically, he might have been bruised a little bit, but he would have been okay. Even though he admits that his head would have gone out the window if he'd had a seatbelt on. And that's all set up by the deposition. And I couldn't wait for this. That played a role in making the decision never to concede any comparative, because we felt like, first of all, we could say we don't know whether he used it or not, whether somehow the belt failed. Yeah, there were no witness marks, but we don't know. And Hayes did a great job of talking about that. And we had the vehicle. Always preserve your vehicle, ladies and gentlemen. You need to keep in the products cases. And you know, that is something that you need you can work with the insurance carriers. They can preserve vehicles for you. There's a lot of different things that you can do to keep that so that you can later look at it. But in this case, the nature of his injuries demonstrated, in our opinion, that he would have died whether he had a seatbelt on or not. And that's why I felt comfortable that we could take that position. And because Pizziali overreached, in my opinion, so dramatically in his depo and would have to overreach at trial, this again, you got all this notice, all this information about Ford knowing the problem, and now they hire this guy, which you'll see, we use this in the punitive damage case, to just, again, say the company line. So it was, I think, from my standpoint, I did not feel like we would ever need to concede anything on that. Let's go to the next slide.
And again, take this away, because one of the most memorable parts of this trial was how you presented the wrongful death damages for Susan Mauro and her kids. Really compelling. So I want you to talk about that a bit, Roger.
Okay, so wrongful death cases are, very few of them ultimately really get tried. It seems like people don't want to take the risk of going to trial on wrongful death cases. There is a nuance to them, and the lawyers that do try them have found that connection of how you can communicate to a jury and argue damages. I've had cases where jurors have said, you know, I can't do it, and they just mentally can't wrap their hands around the issue. And you need to be able to communicate that you're not talking about the value of the individual, which is what people immediately go to. You're talking about the loss to the survivors. What have they lost? And then going through the task, getting them to commit in jury selection so that when you make these arguments and close, they're ready to engage in that process of valuing loss to a wife, valuing loss to the children. There's a litany of things you have to decide. Some judges will let you divide the parties, some judges won't. The statute is pretty clear. It's a single action. We've been successful on separating. I wouldn't tell you what's the right way to do it because I don't know. I just know I've done it both ways, and different cases lend themselves, I think, to doing them as a family unit because that's what people understand. We had a tremendous amount of photographs. And that's not always present in every case. We had video, but what we also had in this case was Tony was a musician, and we're going to show you something in a second. But let's stay on this slide. You'll see in the background, we have dates. To me, the one thing that resonates with jurors more than anything is time and how valuable time is. And this case, we waited 7 years to try this. This family had 7 years before this case went to trial. And that's something all of us now are going to have to deal with because we're going to lose a year. And cases aren't going to go to trial as quickly as maybe we'd like them to go. Instead of whining about it, embrace it and use it because you have more time where they don't have people in their lives. And the ability to communicate time is what I do is I use calendars and I go through time and I talk about events and growth, especially when you have children and going through seminal and important events, milestones in their lives from marriages to birthdays to holidays. And these feather into all of your photographs that you can then tell the story in. So I went through 7 years of this family not having Tony Mauro. And then that allows you, go to the next slide, to talk about all the other different elements. You have your economic damages and your non-economic damages. This is just simply a slide that shows you how we go about it, or at least back then that Brian had developed a technique where each one of these would get highlighted as we went through the different elements and reminded the jury as to what the evidence is they'd seen. So let's go to the next slide. Okay, now before we do this, so one of the benefits I had, and I've mentioned his name before, is Mr. Bale, who helped me. Bob is also a musician, and he thinks in his own mind a very accomplished musician, but he's very talented. And so Tony, as I mentioned, was a musician. He's in a band that plays for the church. So this again goes to a situation of you have to find out, you have to interview your clients, you have to find out what evidence you have, and then you have to go through it. Bob spent hours going through audio of Tony Mauro to find the right 1 minute audio of him playing his bass guitar. Okay, so how do you get that in evidence? Well, Susan Mauro laid the foundation by saying one of the things that she really misses is not hearing her husband practice and play his bass guitar, which is a very soulful instrument. And so we laid the foundation, we played this audio. It is 1 minute. And again, you're not supposed to have music in a courtroom, but it was part of her loss of not hearing him play. So we got it in and we played it. We also got in all the foundation. This is Bill Burnell, who was the other individual who was killed, and Tony on the right. And so we got in all these other photographs. And so when it came time for trial, rather for closing argument, what Brian did is Brian did a video of photographs that were in evidence with the background of the 1 minute bass that was in evidence. And Warren, what could he do? It's all in evidence. So we just presented our evidence in this fashion. Think about this case. That's the first time they saw that. They didn't see that during trial. That's also the first time that defense counsel saw it. You play all this notice, you give them all this evidence of notice of what Ford knew, the history of the vehicle, all the data that had been cultivated, and that builds to your wrongful death and your punitive damage case. And the power of music is obviously apparent.
We just have a couple minutes on punitive damages. And Roger, you kind of took the lead on this, but let's go to the jury instruction next.
And I would tell you, I mean, you can read the jury instruction.
Right.
This is the elements that you have to prove. Again, it's your blueprint. Let's go to the next slide. And this speaks to the collaborative event of attorneys working together. We could not all do the same thing over and over again. The judge would not allow us to do this. And Chris was very, very wonderful. I did the closing, and we couldn't just say the same thing over again. So a lot of her baby had been developing this case in the 350 and the Ford and the testimony, and she allowed me to do the closing relative to Ford because it feathered again with the death case. And it was a really tremendous gift that she gave me to allow me to do that when a lot of this had been her creation and her development. This guy Vondal we're not playing you his video, but I did play it in the punitive damage case. He was my favorite witness, as I indicated in closing, in terms of he's the head of safety, knows these things, and yet nothing's done. Let's go to the next slide. This is a slide that we created just to show how much money Ford put in, because we're now in the punitives and having to assess what's going to punish them. I used as a jumping point just how much money they spend over the course of time with their experts. And these numbers, Lee Carr, probably one of the most enjoyable cross-examinations I ever got to do in a trial was of Lee and Pizziali. But look at these numbers that Ford had invested in these people. And Exponent, that number seems awfully small. Probably should put a 0 behind it now. But they put so much money into defending these cases that we were able to show this number, 175 to 185 million. Go to the next slide, please. And we were able to show what kind of a slice that was of their net worth. You have to have an expert. I had a wonderful economist who did my economic damages, Barry Benzion, just an extraordinary expert. But we also got him to look at the books for Ford, and he testified in the punitive damage case as well in a very powerful way. So we argued for just 3% in punitives. The ultimate award was 50. Let's go to the next slide.
Hey, Roger, real quick.
Sure.
I don't think we mentioned the fact that Ford did not have punitive damages bifurcated in this case. So they made a strategic decision to combine it, and I'm not sure why. Don't think it worked out for them, but we were able to put this evidence in and argue it all in one closing. And then the list here, these are critical dates that came from the series of documents about what Ford's internal standards and safety protocols were. And we were able to show that they hadn't followed their own guidance and guidelines. They set their own duty of care and then they didn't meet it. And that really came through Mr. Vondale. Kind of used him as a historical looking back. He was the guy in 2002 and 2003 that was looking at the history of these 15-passenger vans and basically saying, we don't have a problem. These vans are fine. And we were able to use him to get in all of the evidence of what Ford knew and what their protocols were. And so let's go to the next slide. Keep going. Yeah. So this is just, again, this is Mr. Nasser in contrasting what Ford did in the Goodyear tires to what they did in the Firestone recall. It really tells you how they dropped the ball here. And it was, they did it, they knew what they were doing. Mr. Nasser said, this was back in 2002, Ford Motor Company will not rest until the Firestone tire recall is complete. Well, they sat on their butts when it came to the Goodyear recall. Let's go to the next slide.
I didn't say that in closing. Okay, let's make that
no, but we can say
way.
And then this is just the kind of summation slide that, you know, laid the key pieces of liability for Ford. Do you want to say anything about that one, Roger?
No, I think we've made the point. I mean, you have to put so much information out there in a punitive damage case to get the jury to the point where, like in this case, when the punitive damage award was read, the foreman raised his arm up in a fist when it was read. I mean, that's how powerful the evidence was, that they felt empowered to do what they did.
So we have a couple of slides that just show the verdict form and what the outcome was. This is from the denial of the motion for new trial and the entry of judgment by Judge Abbott. So go ahead, next slide. This one is really, to me, the culmination of all of our work. Ford Motor Company, 59%, Goodyear, 41%, 0 on Tony Mauro for a seatbelt, 0 on Bill Brownell, the driver, 0 on Sears or Walmart or Suburban Ford, who all touched the vehicle with the recall tire on it. this was dramatic. And then the next slide, Roger, this is the culmination of your argument on and evidence on the wrongful death damages.
And I think this speaks to this issue of time. We complain now about not getting cases to trial. Use it. I mean, you have more time where people can talk about what they've been through, whether it's an injury or a death. And people you look at these numbers, he was, I want to say late 40s when he died. This is how much this jury valued past loss of all these things that go into your elements of wrongful death. And again, this case was an extraordinary case on so many different levels that we literally could break down just this part, the damage part or the punitive damage part or the liability part into 2-hour seminars. I mean, it was a very target-rich environment for us to present the case. We just feel very fortunate to have had the opportunity to represent the family and to work with you, Chris, in such a collaborative way. I mean, having never tried a case with Chris before, it was like the two of us have been working together for years. It was, and everybody played a role in that. Bob Bale assisted us both tremendously, unselfishly, in a way that really helped us put this case in the position it did. But it just speaks to the fact that you can work with other people. You should work with other people. I learned a lot from Chris, and I think she might have gotten a nugget or two from me in the process, but it's important to collaborate.
Absolutely, it was terrific. And the last slide we have is just the punitive damages, malice suppression, yes, and then the 50 million award for punitives. It was a remarkable verdict, and Roger, just working with you was terrific. And I think we have time for a few questions. Bruce, are you there? You want to come back? It's 11:30.
Here I am. Pretty good, huh? That was really good. And I want to emphasize, Roger, she learned more than just a few nuggets from you. She would come back to the office on the weekend or whatever and talk about this that Roger did and that Roger did. And the way you all work together, I mean, we all have big egos, and to get egos all to fit in one courtroom and work together is a remarkable achievement. I want to emphasize to everybody, to really make the point on this. Roger has been the ABOTA Trial Lawyer of the Year, the CAOC Trial Lawyer of the Year. He has an impeccable record. I mean, look at everything on the wall behind him there, and that's just a tiny piece of it. To make the decision to put your ego aside and do something in the best interests of your client, I mean, that is the highest calling that a great trial lawyer can have. Help your client win. It's not about us. It's about the people we represent. So just kudos up and down. And by the way, Roger, I think 3 or 4 of the auto design cases I've tried were in tandem with Chris. And I know what a power she is in these cases. My gosh, she knows where all the bodies are buried. And there was one case that we did together. Warren was on the other side, Warren Platt, and she did a couple of cross-examinations on Friday afternoon that the witnesses were looking at the clock, Ford witnesses waiting for the afternoon to end so they could get on a plane and get the heck out of Dodge. It was as if their skin was peeling off their bodies. It was such great cross. So the two of you together, I mean, what a dream team. I just want to say that. So, all right, some questions.
I appreciate it, Bruce. And I would say, to speak to the topic, that you have to feel good about yourself to do what you do and get in front of a jury, certainly. And it's certainly ego strength, but we have a great responsibility as civil trial lawyers. And I've dealt with a lot of tremendous defense lawyers that also are excellent at their craft and love what they do. But this process that we all have the ability in the civil justice system to protect our clients and represent our clients is, if you think about it from a money standpoint or from a personal standpoint, and a lot of these things are I appreciate you mentioning, but a lot of them are just they're actually scalps for me from that remind me of the efforts and the time that I've spent in doing a type of job that we all are lucky enough to have that makes it better for everybody. It's like wearing a friggin' mask. We're trying to help each other out. And
Yeah.
as a civil trial lawyer, we're trying to help everybody out. It's a great job, and we're all very, very fortunate to have the opportunity to do it.
And every one of these verdicts is part of a chorus of verdicts across America that are saving people who have not yet been hurt, but would be if the verdict didn't happen and force companies to do better with the way they do their products or build roadways or whatever. So many kudos. So I've got some questions here to ask. One of them is somebody wanted to know whether all of these slides were actually used at trial or some of them or most of them. What's the answer to that?
All. They were all used at trial.
Okay.
I mean, they were used in closing, our closing. I pulled out slides from the closing. So yeah, I would think, and we showed you stuff that came in.
Yeah, okay. And then another question that somebody had was, because I started out talking about the challenge of getting a verdict like this in Sacramento, Chris, what happened? Chris, come back. Well, anyway, because this question is for you, Roger, this lawyer was thinking about expanding his, hey, welcome back. This lawyer was thinking, this lawyer was thinking about expanding his practice into Sacramento and wanted to know how tough it is. So what's your summary on that?
It's impossible. Okay. So I would tell him that it's very, very hard.
Okay.
I think in seriousness, I've tried cases all over. Up here in Northern California, we have a lot of counties and communities that are viewed to be red and conservative. And my experience is that jurors are human beings. You got to do a great job of doing your jury selection and preparing your case and prosecuting it effectively. I don't care where you are. And I've tried them down there and tried them up here and tried them in other states. People are people. And sometimes we maybe forget that when we see the politics and how certain people are supported. You can't imagine anybody would. But Sacramento is no different than LA. It's just maybe, from a socioeconomic standpoint, awarding numbers is different, but that's the lawyer's job. I mean, I've been in Butte County, which is considered to be horrible, and gotten extraordinary results because the people understand what value is.
Yeah, yeah. So Chris,
Yeah.
I've seen you do it for so many years, putting together, finding the documents, making the connections, getting the video depots. How do you go about doing that? Do you do it all on your own? Are you connected nationally? Explain it to everybody.
I would say the single most valuable resource for these auto products case is the Attorneys Information Exchange Group, which I've been a member of since my young lawyer days. And it's a national organization of lawyers who represent plaintiffs in cases against auto manufacturers and tire companies. It's evolved into more than that, but it started out back in the late 70s, early 80s with the number of lawyers who were doing the Ford Pinto fire cases and the Jeep rollover cases. And the motto of AIEG is sharing, success through sharing. And I learned so much just from the technical issues, how to talk about Delta V and rollover resistance and all of that from those lawyers and experts, and also just being able to get the information that somebody else has dug out. As I think Roger Bruce may have mentioned, when you go into one of these cases, your first fight is over getting their documents and getting their internal testing. And the first fight that you're going to have is, we want a protective order that we're only going to give it to you and you can't give it to anybody else. And if everybody agreed to that, no one would know what had been uncovered by other lawyers that we build on. And in this 15-passenger van cases, for years, Ford denied having any notice or knowledge of test track failures and rollovers. And as a result of the work that lawyers around the country did, ultimately, lawyers in Cleveland found Mr. Shetler, a test driver who had been operating a vehicle on a test track, and it went up on 2 wheels and tipped over on its side. And according to him, it was a tip over event. It wasn't a rollover, but it happened in the 90s, early 90s. And when he was asked in that deposition, did you do anything? Did you report it? No. Why not? Well, it was my failure as a test driver. It had nothing to do with the vehicle. So why would we report it? Did anybody say we should change the design? No, it was my fault. I was the test driver. It's because I didn't know what I was doing. A Ford test driver doesn't know how to drive the vehicle, or maybe it's the vehicle. But anyway, it's that because of those efforts, we had those building blocks to show. As of 2002, are you kidding me? Ford knew how bad these vehicles were, and they continue to defend them in court.
Well, so I think, Chris, a few years ago, you were president of AIEG, right?
Yes, I was.
So I can just tell everybody on that issue, that great issue of collaboration that Roger was talking about. Chris and I have our offices next to each other. She gets phone calls from around the country all the time from people working on auto design or tire failure failure cases, to ask questions and to get information. And Chris gives out that information and helps people all around the country, even though she's not involved in the cases. That's the way, you know, Roger, that's what you were saying. Everybody's got to work together because all boats rise together. Roger, a question I had was, and this is one I go back and forth on, did you have all the clients in the courtroom the whole time, and why or why not?
Again, very case specific. I did have Susan in the whole time, because if the obvious that if you're going to be there as a juror all the time, then you need to be there. But there are cases where you don't, like, you know, not name dropping, but the reality is when I represented the Raiders, I wouldn't let Al Davis get near the courtroom because he would just be so difficult. So you have to assess the case, you have to assess the individual, you have to assess the injury. You know, if you have a traumatic brain injury case and the person looks normal and acts normal, you certainly don't want that person sitting there. You have a widow who's she emotes how empty she is as a vessel because she's lost her husband. You want the people to feel that. You just don't want them to get desensitized. So in this case, we had Susan there. And I think we had all our clients there simply because we wanted the jury to know everybody was really invested. We wanted to get an answer. And these were the people that were entitled to look at the dragon.
Yeah, no kidding. And it really does vary from case to case. There's a question here that includes an appropriate compliment. So I'll just read the question, compliment. I tried a case with Roger and echo Chris and Bruce's comments. Excellent to work with, and I've worked with Chris for years, and she's incredibly skilled. And I've tried a case against Warren Platt to a plaintiff's verdict back in 1997. Was this me asking this question? No, it's not. This came in from a listener. He's tough, meaning Warren Platt. My quick question is, was there an aha moment in trial where the jury saw through Ford's lies, or was it an accumulation of the evidence you presented?
Well, I don't think there was ever an aha moment because we just spent so much time building in our structure. But I would tell you, and this has only happened to me one time in trial, and I've tried, over 150 jury trials. I remember watching Warren Platt do his closing argument, and it's the only time I've ever looked for a trash can because I really thought I was going to throw up. He was so effective, and I really started physically feeling like I was going to throw up. And it was probably the most motivating I've ever been to get up and do the summation and to counter what he'd indicated. So it's not so much an aha moment, it was more of a fighting for my effing life moment. That I think is really what happened.
I would say though, Roger, that the cross-examination of Lee Carr, which we both did, when the jury sees him, and he's a very smooth witness, and he's likable, and he's got that smile, and he's charming, and he's smart. But he had done the dog and pony show. The Ford, it's a great vehicle. Look at all these tests. Look at all the things it can do. And you literally just put, here's this test you showed the jury, and here's the test you didn't show them. And you did both of them. And in this one, it's going off the track. And in this one, it's all nice and smooth. And I think those videos of Ford's own testing internally, those outtakes, scare the shit out of jurors.
Well, I think that the best evidence you can get in a case is from the defendant, and because they can't really dance with their own stuff, and it's not something you manufactured. So again, in speaking to collaboration and effort, what this army of lawyers put together on these different cases, and we're doing cases right now, products cases, that you can't do them by yourself. People have been in the trenches, and the way in which we were led to invite you to get engaged with us on it was clearly the best decision we made. And it's not a function of should we have done it or shouldn't we? There's no doubt. And that doesn't mean that you can't try cases by yourself. Certainly you can, but in cases of complexity, where lawyers have spent a career developing information, be big enough to share it and to work with others. So I think of like the Shetler depositions that you talked about. We have that lawyer was in our courtroom helping us try the case by his examination of that driver. And it's very empowering as a plaintiff's lawyer to work with other colleagues that truly are in it to get the right result, not just so much. I mean, we're always measured empirically, unfortunately. And maybe it's because I'm 65 now. I'm not worried about empirical results as much as I am worried about making sure we get the right thing done. But it is important to work with one another.
Yeah, absolutely. And I'll just say, I just saw who it was that submitted that last compliment question. And it was another great auto design trial lawyer from back east by the name of Don Slavic. So that just shows you, and the way all the auto design lawyers learn from each other, the fact that Don has been on this webinar just speaks volumes. So Roger, I want to tell you, you have no idea how thrilled we are that you became part of our webinar series. I know that the people that watched gained an awful lot out of it. And just to remind everybody, you can download the PowerPoint as part of the webinar. That's your syllabus, and it has a lot of great stuff in it. You can also contact Chris or Roger with questions you have or information that you need. Great resources, and they're both more than happy to help you. Just reach out and get that help. So thank you all very much for attending. Roger, thank you especially. We love you.
Thank you, Bruce.
Thanks,
I appreciate
Roger.
you guys inviting me. Take care, Chris. Love you.
Take care.